always get this sucker to come off. Maybe I can get it now. Are you ready for this dog and pony show?
Ready for the circus. It's gonna be fun.
Should pop some popcorn, sit back and watch.
Yeah, really. Right? You can't stream it to the computer?
I wish I could, because it's not live. It's just going to be recorded audio.
Yeah, that's true.
But Yvonne said, leave both doors open so you can hear it. And I'm like, I really want to hear
Well,
it.
the lawyer doesn't sound like he knows much about this. So when that happens, they go overboard with everything else, and
I know.
some kinds of weird shit happen. It's happened before.
Coming. He's getting ready to go pee. I'm sure they're not getting in here. Orlando! Full compliance officer.
should attend. I'm not sure if I'm sure it's good. Yeah, I know it's going to be cool. I'll ask her.
Call Alan Welsh.
Calling Alan Welch.
Hi, Mayor. This is Alan.
Where's our meeting with Brian?
Yeah, it's going to be just Yvonne's doing the meeting room. I've got 2 more minutes before I get back, but Brian's in the conference room. He's waiting for us.
Okay, I'll go in the I'll put mask on, go in the conference room.
All right, excellent. I'll be there in like less than 2 minutes here.
Okay, bye-bye.
I already called.
Are you trying to get a hold of Sandy about the mic?
Huh?
Are you trying to get a
Oh,
hold
I've
of?
got it figured out.
Okay,
Was she called?
yeah.
Oh, I see she missed her call.
Oh,
I got it figured out.
okay. I was like in the middle of something, so.
For the hearing at 2.
Okay, come in. I'm Yvonne.
Hey, Yvonne.
Are you?
Alton Hale.
Okay. This is going to be where you'll sit.
Okay.
Sanitize everything right now, so don't, it's a little wet. The stenographer will sit over there. And these microphones are extremely sensitive. You have to talk right into them. You can't like look away.
Okay.
I will remind you. And our bathrooms are right around the corner.
Perfect. Hello? Yeah. Yes. Yeah. Okay. Well, send them anyhow, and I'll talk to the judge about it, we'll figure it out. Okay? Thanks.
meetings right now by our mayor, so I'll be happy to step out.
That'd be great.
Okay.
I appreciate it.
I'm gonna take my phone. This door's locked, so nobody can come in.
All right, you want me to let them in?
No,
Okay.
I'll let them in.
Okay.
I'm gonna monitor that. I'm gonna close this door because our code officer's office is right upstairs, so I'll close that so you're private.
All right, thank you very much.
Mm-hmm.
All right.
Okay. Hi, are you here for the magistrate? And what capacity? Okay, okay, the witness, okay, you might have to stay here, I'm seeing how many people have to be in there, we might have to wait for you to call you in 2 minutes. Okay, what's your name? Okay.
Yeah, this is,
You want to go next one too? Okay.
But I totally agree with that.
Okay. Okay. No problem, I just didn't want you to wait. Oh, she's with the mayor? Oh, please. I knew you were done with somebody, I didn't know.
No, that was, utilities.
Oh.
We're just hanging out right now. We'll sit down.
You sit down. You can sit, and you can bring out, is your court
We'll
reporter
finish everything.
coming?
Well, I'm gonna tell the judge, court reporter's running late, but it's transcribed, I don't have any problem.
We record it, I record it, so that's fine. And y'all work with have both of these tables in and spread out if she's not coming. So, because they're gonna have three and y'all can have three, so we're all equal. Okay.
Okay.
And, we'll bring in people that need to come in as they are required, and if they're not required, that's all they come in. So,
Fair enough. Is a special magistrate here or coming?
he's coming, I've been waiting on him, so,
Okay,
I don't want him
Somebody
to
sounds
have
a liar.
I don't want him to have to knock on the door.
okay.
He's really tall. Yeah. chairs and all spread out.
Everybody ready, or you need a couple more minutes?
We're on and ready to go.
Are we ready to go? Okay. All right, good afternoon, everyone. My name is Glenn Tarsivia. I'm the magistrate today for Town of Palm Beach Shores. It's February 17th, 2021 at 2 p.m. Give everybody a little overview. The way the process works is the case is called, and I see we only have one case on the agenda today. We'll give, is that better? Okay. Once the case is called, we'll give each side the opportunity to present their case. Generally, the town would proceed first and present their case. Next, the respondents would go. Of course, each side would have the opportunity to cross-examine any witnesses, introduce any evidence that you'd like to present. To save time, I'll swear in all the witnesses whom we anticipate testifying today, which ask you all to raise your right hand if you're going to testify, and swear or affirm that any testimony that you're going to give today will be the truth, the whole truth, nothing but the truth. All right, thank you very much. And counsel, will each side please state your appearances?
Sure, Amity Barnard, Assistant Town Attorney for Town of Palm Beach Shores.
Okay.
And Matthew Pritchett is also here. He will not likely be speaking, but he is also here from my firm.
All right, and for the respondent?
Your Honor, my name is Alton Hale. I'm with the Siegfried Rivera firm. Before we get started.
If you could remove your mask, we cannot hear you. It's not recording. Thank you.
Yes, ma'am, but I'm trying to also maintain social distancing.
We understand.
Okay, so,
I know, it's trying times, we're all in. Do the best we can to remain healthy.
yes, Your
I'm sorry,
Honor.
was it Mr. Hale?
Yes, it's Alton Hale, Your Honor. I'm with the Siegfried Rivera firm, and I need to make a motion before we start here today and present some facts to you with regard to a motion for continuance in what we consider violation of due process as well as improper notice.
Hold on,
with
sir.
regard to this hearing.
Can I interrupt you? Let me just read the case into the file.
Sure.
We were just doing appearances. I didn't realize you were going to get right into the merits. So we can just read the case in, and then
Okay.
he can proceed, just so the record is clear. Special Magistrate, this is a violation hearing. As you said, it's case number 20 PBS-0264, Anna Bednarek and Slowomir H. Walrus, 218 Sandal Lane, Palm Beach Shores, Florida, 33404. Thank you, Special Magistrate.
Okay, and you want to make a motion for continuance?
Yes, Your Honor. If I could lay out the facts for you on how we ended up here today.
Okay, well, I'll ask you two questions. First, have you all discussed the continuance?
Yes, Your Honor.
Okay.
So-
And then, secondly, when you're talking about the facts, you're talking about the facts to justify continuance, not getting into the merits of the case.
That's correct, Your Honors.
Okay, and before he proceeds, any objection or?
No, sir. He and I did speak on the telephone yesterday. He also has corresponded with town staff, but I did speak with him verbally on the telephone last night at about 5 o'clock.
Okay,
Yes, Your Honor. If I may proceed?
sure, thank
All
you.
right, Judge, if you have the notice of violation in front of you,
I don't have anything in front of me except the
May I
notice of the hearing.
approach?
Yeah, I wait till I receive the evidence during the hearing.
fair enough, Your Honor.
If I could see that before, just so I know that I don't know what he has.
Okay. Also, while you're looking at it, I'm assuming that you've not agreed on the continuance, that's why we're happy.
No, sir.
Okay.
Thank you, sir. No objection to that.
All right. Thank you. Okay, so I will receive into evidence from the respondent a document entitled Notice of Irreversible Violation and Notice of Hearing. It's regarding these respondents and at an address of
If I may, Your
218 Sandal Lane. Okay.
If I may, Your Honor, if you note the date of that notice is February 3rd, 2021, which is exactly 2 weeks ago. In addition,
Sir, I'm sorry, it's not recording, and I must have it recorded. Thank you. If
Yep.
they need to separate, then we need to separate them.
Your Honor, also, I ordered a court reporter, but my secretary called me about 15 minutes ago, and they are running late, so we will have a court reporter, but I told him I didn't object to proceed as long as it's recording. But, Judge, if I may, that date is February 3rd, 2021, exactly 2 weeks ago, Your Honor. I have a copy here that I'm going to show to the court, and I normally bring extra copies, Judge, but I will get into this, but I was retained on Monday of this
Understood.
week. And I will, hold on.
If I may approach, Your Honor? Certainly, thank you.
Your Honor, if you note, the date of that envelope is the envelope that my client received this notice on, where it was sent February 8th of 2021, which is last week, Your
I'm
Honor.
just receiving into evidence respondents exhibit number 2, which is the exterior of an envelope addressed to Ms. Bedarnik in Illinois, and
Magistrate, we can't hear you.
I'm sorry.
Thank you.
Sorry, received into evidence respondents exhibit 2, which is appears to be the exterior of an envelope from the town of Palm Beach Shores to Anna Bednarek, Bednarek, in Illinois, and the postmark says February 8th, 2021.
Yes, Your Honor. And so upon receipt of that letter and notice of this issue, Your Honor, my clients contacted my firm, and I spoke to them, I think it was either Thursday night, where I had just finished a 2-day evidentiary hearing, or Friday, and I agreed and told them I'm going to try to move for a continuance, and I'll get them a retainer on a federal highway on Monday. I attempted to get a hold of Mr. Rodriguez from the notice. I called and left a message on somebody's voicemail at the town. And then I sent an email that said, I was just retained, can I get a continuance? And I also asked, can we appear by Zoom? So the court knows my client lives out of state. So that, I spoke to Ms. Browning, who informed me, Your Honor, and we can put her under oath, that it was my client's fault that he did not hire an attorney sooner, Judge, okay? He receives this notice on the 11th. Either that day or the next day, he reached out to my firm, spoke to me. I sent a retainer on Monday. And I can also believe, I'll put Mr. Rodriguez under oath, I believe that he's had multiple contact with my clients over the last year, knows their cell phone number, did not reach out to them and explain what's attempting or what the town was attempting to do. And you know, they send it by mail, Your Honor. I then sent a follow-up email and I said, could you forward my request for a continuance to the special magistrate? And when I spoke to Ms. Browning, I said, who's the special magistrate? And she says, I don't know who's showing up, but it's this firm. And quite frankly, I looked at your firm, Your Honor, and I didn't know who was going to show up. And then I got a call from Ms. Barnard, and I explained to her, I said, look, you know, I don't think this is sufficient notice. I just got retained. My client did, despite what Ms. Browning said about my client should have been hired an attorney sooner, he acted very promptly. Can I get a continuance? Her position was the town's position, we're not agreeing to that. I then told Ms. Barnard, and I said, look, I've been looking at the codes, I've been looking at the notice, and I'm not sure what you're saying my client did wrong. And so what will be presented, I think, at a later date, these dates they have, they're just incorrect, Judge. And Ms. Barnard's response to me is, because I said, look, are you saying he shouldn't rent at all? Are you saying he rented too often? I mean, what are the claims against my client? Her response is, you will find out tomorrow. And Judge, I personally think there's some due process issues that the town attorney either would not or could not explain to me exactly what they want to apparently fine my client up to $5,000 per day according to the notice. So based on that conversation, I told my client, hop on a plane, come on down, try to gather all the paperwork you can, and they were able to gather some paperwork. Judge, I believe the town told me, or trying to make the case, that this is somehow irreparable or irreversible violations. Can I present a case to you, Your Honor?
Again, we're only on the motion for continuance. I feel like we're getting into merits.
Their position is they don't need to give me notice, or my client's proper due process notice, because it's an irreparable or irreversible violation. So,
Let's, if they make that argument, then I'll receive the case.
okay.
Yeah, I hear you're anticipating their argument, but let's see what their argument is on the due process issue. Again, because at this point, I'm only considering continuance, and I guess one question is, how long of a continuance are you seeking?
Judge, I would want a couple weeks. I don't know what the witnesses are. I mean, basically, Judge, I showed up here today not knowing exactly what they're saying my client violated, because when I asked the town attorney, could you just explain to me exactly what, is he not supposed to rent at all, or he's rented too often? I did not get a response, Judge. So I'm not clear today what I got to fight against. And so I would want a minimum of a couple weeks, and I could tell the court without getting, I've got paperwork documenting that their allegations are incorrect. Maybe it all goes away. I don't know. But I just think this, Judge, I think this is completely unacceptable that you want to charge a member that owns in this community $5,000 a day, setting a hearing less than 2 weeks out. You have that person's phone number, and you don't call them, you don't try to contact them, and you toss something in the mail, and then when I ask for a continuance, and he promptly hired a lawyer, Judge. I mean, you're in the private profession. He calls me like that day or the day after, and I turn around a retainer letter over the weekend on a Monday, so I could call the town and say I've been formally represented. He got it back to me within a half hour to hour. I think this is just a complete violation of due process, and I'd ask for a continuance of at least a couple of weeks, Your Honor.
All right, let me hear from the town again. Try to limit it to the continuance issue.
Yeah, so with regard to the conversation that I had with opposing counsel, I gave him the professional courtesy of calling him yesterday at 4:45 after I was forwarded an email that he sent to Town Hall after Town Hall had officially closed. So I gave him the professional courtesy to call him and at least acknowledge that we had received the response. He had already been told earlier that morning by the town clerk that the town's position is that the hearing would proceed today. This is a very small town. This is our normal code enforcement hearing day. I reiterated the same thing to him last night on the telephone. He then wanted to discuss the merits. I have no obligation to discuss the merits. I told him I didn't have the files in front of me, but he had the notice of violation. It very clearly states what the violation is. I don't want to get into the merits, but I told him on the phone last night that the town would not support a continuance. This is a small town. If he reads the statute, he will see what notice is required and what due process is required. We have met that. So, to address the conversation, that's all I want to say on the record. My hope is that you will deal with the continuance prior to getting into the merits.
Let me ask you a question on the notice issue. What was the notice that was provided?
The case file, which when we get there you will receive, has an affidavit of posting on February 5th, which is the same day that the mailing was sent certified mail. So it was not only mailed to the property, which is required by state law via certified mail, but it was also posted to the property.
Okay, so you're saying it was mailed and posted on February the 5th?
Yes, sir.
I'm sorry, mailed and posted on February the 5th. Okay, that was a Friday. And apparently it was postmarked on the following Monday by presumably the post office?
Well, no, the copy that we have in our case file has the date of February 5th on it, so I'm not sure where that February 8th has come from.
Okay, let me see a copy of, I'd like to see both the affidavit of course, show it to opposing counsel. I'd like to see the affidavit.
Do you want it out of this?
Let me ask you both a question. Any objection to me receiving the case file, as long as I limit what I'm looking at to just those documents? I don't really care whether you take it apart and give it to me in pieces or give me the whole thing. That's really up to the two of you, how you want to do that.
Judge, I would just like to see something before it's given to the court, because...
You know, why don't you share the case file? Because you're going to show them that if we proceed today,
Correct.
and if you don't proceed today, you're going to get your preview of the case then. So I'm presuming you haven't seen any of these documents before. So why don't you take a couple of minutes to look them over, focus obviously on the continuance issue, but I don't want inadvertently to, accept into evidence some other part of it that you're going to object to. And I'll even go further and say, I'm going to reserve your right to object to substantive stuff subsequently, because right now I'm really only looking at those couple of pieces of paper. And unless it's easier for you, just give me those couple of pieces of paper.
That's plenty easy. If you want me to take them out, that's fine. I don't have any opposition either way.
Okay.
So the first is the affidavit of service. That's a photograph of the posting to the property on 2/5. And that's a copy of the envelopes that the code enforcement officer mailed on 2/5
To where?
to the address there. And then the final document is the notice of violation and notice of hearing, which you have.
I don't object to this, Judge, but I will make some arguments on it.
Okay.
Thank you, sir.
Thank you. All right, for the record, I'm receiving into evidence as Towns Exhibit 1, what appears to be the same notice of violation that's already in as Respondent's 1, only this one has a certified mail receipt, which is signed for, apparently by the Respondent, on February the 11th, 2021. Also receiving as Towns Exhibit 2, what appears to be envelopes to the same, get the Respondent's number 2. To the same individual, Anna Benarek, at the same address in Illinois, only these indicate a postmark of February the 5th, 2021, and one is mailed regular mail, because it looks to be copies of 2 envelopes. One seems to be mailed regular mail on February 5th, and one mailed certified mail also February 5th. So, obviously, I'm not sure in our discussion or argument on the Towns 2 indicate February 5th, and yet the postmark from the post office says February 8th. Although I will note that, and let me ask the respondent, do you have a more complete picture of the envelope? Because this only shows about 2/3 of it.
I printed out what's sent to me, but let me show the defense counsel. She zoomed it in.
So that's the 2/5.
That's correct, but that's February 5th, but for the record, somehow West Palm Beach stamped it on February 8th.
All right, so that's logical, because I've been dealing with the post office like all of us have for many years, and so it looks like they dropped it in the mail on February 5th. By the time it got to the mail processing facility and was stamped by the post office, and I mean, the general mail processing facility is on Southern Boulevard, probably about 8 miles from here, so maybe they walked it over there. But either way, dropped in the mail on February 5th, processed by the post office on February 8th, received by the respondent, at least the certified mail was received on February 11th. And then the next exhibit is a posting of the notice, which seems to be a, front door with an envelope at the front door. And this was the one that I think you've indicated in the affidavit of service, so this will be a Composite Town Exhibit 3, that the code officer said this was posted on February the 5th. So let me just ask both of you this. Is there any dispute factually that, of a couple different things? First, it was posted on February 5th. Second, that it was mailed on February the 5th. Third, that it was the post office in West Palm sent it out more or less on February 8th, and it was received on February 11th. Are those dates all in agreement, or is there a dispute about any of that?
Your Honor, if I may, I'd have to look at the postage stamp again, but I know you can stamp stuff on a specific date like my office does, but you can stamp it. It doesn't necessarily go out. I'm not sure if that's a West Palm stamp or the internal Town of Palm Beach stamp that was stamped on the 5th. So I don't know if it was in fact dropped in the mail on the 5th. And without it in front of me, then I handed it to the court on that issue. Do you understand what I mean, Judge?
I understand.
Your offices have, when you do high volume, and the town may do high volume instead of putting stamps on that. And I could tell the court that there's been times where somebody doesn't drop it in the mail like they're supposed to, and it doesn't go out to the next day, or potentially, if it's the 5th and the 8th, maybe the Friday to the
Right.
Monday. So
I'm gonna assume, unless again there's some argument otherwise, that the town, quote, mailed it by putting the stamp on it and dropping it in the mailbox on February the 5th. Now, from the time it got to the mailbox, because again, if they put it in the mailbox at 5 p.m. and the mail was picked up at 3 p.m., the mailman, mailwoman is not going to pick it up until their next rounds. And I think, looked at the calendar, February 5th was a Friday. So very easily could simply be that it was dropped in the mail that day and the mail person didn't pick it up until either the 6th, assuming they have Saturday mail pickup, and some places don't, or picked up. Either way, to me, what's important is really the two important dates are the date your client received it, which seems like February 11th, and I can ask, did they receive the regular mail copy also on the 11th?
I will tell you, Judge, what happened was what they left, they had a guest in on the 10th. They got a text of it. And they then, I think that day, called my office, but they got the one by mail or registered mail on the 11th, which, for my purposes, still, you have less than a week to be prepared for this hearing.
That's my next question, is February the 5th, when the code officer posted the property, and you just indicated that your clients...
My client lives out of state, Your Honor.
Right, but they received that posting, apparently was posted there on the 5th, and a guest, as you said, took a picture of it and texted it to him on the 10th.
That's correct, Your Honor.
Okay. And is there any dispute that it was posted on the 5th? I mean, we got a code officer signing an affidavit that he put it up there on the 5th.
Judge, I am not stating that the code officer is making any sort of false statements. My overriding point, Your Honor, is the earliest my client knew about this was on the 10th of February. It is February 17th. And I do have an issue if there's a statute that says you're supposed to, when you allege, Judge, and I will quote it, this 16206, when you're alleging that there's some sort of irreparable harm, is the code inspector shall make a reasonable effort to notify the violator. And I suggest to the court, you know this person's phone number, you have communications with them in the past, you know they live out of state. Posting it at their place where you know they're not there and not calling them and dropping it in the mail is not making a reasonable effort to notify these people in a timely manner, to retain counsel, and to have due process to be prepared for this hearing.
Any response to that?
That if I were here before you and I said we called him and we didn't post it in accordance with state statute, he would make exactly the opposite argument, that that's not consistent with what the law requires. We followed what 162 requires, which is that it's sent certified. We made a reasonable effort. We made even more of a reasonable effort because we also posted the property to ensure that they had as much notice as possible.
Yeah, I mean, just so you know my thought process, you know, I don't think it's reasonable to expect that a town would pick up the phone and call residents. I mean, that's, you know, I don't want to use the word babysitting, but the town's not required to babysit residents. If they followed the statute and posted it, mailed it, certified, you know, I'm not getting to the issue of was that still enough time, but theoretically, you post property that I own on February 5th, I'm imputed to have that notice on February the 5th. Whether I live out of state or not is my choice. I still own property in a certain location. I still have a guest or a tenant or a renter or whatever at that property. You know, I don't know whether the guest was there February 10th.
Judge, can I
Sure.
speak to that? If you look at the enforcement procedure on 16206, there's two ways they can do this, that in my understanding, Your Honor. One is, if they think a violation of code is found, the code inspector shall notify the violator and give him or her reasonable time to correct the violation. They didn't try to do that, right? They just set this hearing. So they didn't do that. And the secondly is, if they try to eliminate the opportunity for this person to correct the condition that they're being accused of, they're supposed to say, make a reasonable effort. That's what the code says. That's what the statute says, Judge. And I understand what you're saying about a town is not babysitting, but I think the evidence will show that Mr. Rodriguez has called my clients before. And if you're not going to give these people to the extent you think they did something wrong and just go straight to a hearing on this without giving them an attempt to cure, make some reasonable notice when you have their phone number and you never let them out of state, Judge.
Well, let me ask the town's attorney, because again, I'm not getting into testimony yet from either Mr. Rodriguez or your client, so I'm doing all this as proffers. I'm sorry, doing all this as a proffer. Counsel, was there previous communication between the town and these owners?
Yes, and the code enforcement officer will speak to that. They were as part of the business tax receipt and certificate of use application process. I don't know what he's speaking about in terms of telephone conferences. The code officer would have to speak to that. But I am aware of previous communications having to do with the BTR approval process and the certificate of use approval process.
Was there any previous communications that indicated that they were in violation before this notice violation? And I'm not just talking about a formal written notice, but to the best of your knowledge, phone conversations, in-person meetings, anything where the respondent would have been on notice in the town's position that whatever was going on at this property was a violation of the code?
Yes, again, I'll defer to the code officer, but my understanding is that as part of at least two conversations, it was explained to the respondent how he could and could not rent the property as part of his BTR application and subsequent inspection.
All right, let me throw out an idea to both of you, because I'm a big believer in due process and also a believer that, you know, attorneys should have a reasonable chance to defend their client, and, you know, there's a dispute over whether the client should have gotten notice on the 5th or when he got it on the 10th, and now it's the 17th a week later. The rental of this unit seems to be the issue, right? If I'm reading this correctly, it's all about somebody other than the owners living at this unit. Is that the gist of what we're going to be arguing?
I think so, Your Honor, but I will tell the court, I'm not clear, and I asked this directly. Are you saying that they're not allowed to rent it at all? Or are you saying they're renting it too often? I mean, what is my client accused of? And I still don't know.
Because my suggestion, and again, if it's no skin off my nose, I'm not going to be offended, is if your clients would agree not to rent it for 2 weeks and you would agree to a continuance for 2 weeks, is that but again, they may on the other hand have somebody that's signed a contract to rent next week and they couldn't agree to that, and I don't want to put you in that situation at all, and I don't know if you agree with that, but it seems a fair compromise where if the town is objecting to a certain use, if they agree to voluntarily refrain from that use for a week or two, and then we can have the hearing at that point, that's a compromise. If you guys want to talk about that outside, that's okay. You know, if you want to take a 5-minute recess, it's up to you all. It just seems like a way to, in a way, split the baby where you get an opportunity to more thoroughly prepare, and the town achieves on a short-term basis what seems to be a goal of having the property not rented. Is that something that you all want to talk about?
Judge, I would like the opportunity to talk, and I can say again, could someone state on the record now whether they're saying it should not be rented at all, or is it long-term rentals? I still don't know the answer to that, and it seems like a basic question to tell me what you're saying my client did wrong.
And as I said to you verbatim last night, you have a notice of violation which very clearly explains what the violations are. You should also ask your client, because he's been explained by the code officer on multiple occasions what the violation is. I don't customarily discuss the merits of cases in advance of hearings, nor do you speak with opposing counsel at trial and you know, go over your entire legal theory.
Judge, I'm not asking the merits. I'm asking, what are you specifically saying? Judge, can I not get a simple question? Are you saying my client cannot rent this at all? Or are you saying he's not renting it the proper time period? Instead of saying, look at the notice, look at the notice. If I knew, Judge, this is basic due process.
Well, I don't have the code in front of me. I mean, I'm presuming you've looked at what these sections of the code, 18.1, 18.2, 18.16, PF 222, and PF 5.1.
And the notice very clearly states, I mean, again, if they're asking for a continuance, we're getting into the merits of what's to be litigated. So if we're going to litigate, let's do it today. If we're going to get a continuance, let's leave this to the motion to continue and not get into the merits. The notice of violation clearly states what it states.
Judge, I'd ask you to look at the violation. What I could tell the court is, maybe the problem is they've accused my client of renting in certain time periods, and he scrambled to get plane tickets and car rentals. So what they've said, without getting into the merits, is, again, Judge, I don't understand why it's hard to tell me in direct manner, are you saying it's short-term rentals? Are you saying no rentals? I don't understand why that's a fight, Your Honor, honestly. I just don't understand.
Well, again, I can't force either of you to share your theories of your case. I would like to think that those sections of the code, and again, I don't have them in front of me, I don't have them memorized, would provide some clarity. Let me ask this from the town standpoint. If there was no rentals occurring for the next week, would that lead you to not object to a continuance for a week?
Judge, if I may, I'm just interrupt here. There's a guest there, but it's over 30-day calendar. So I don't know if they say that's in violation. That's the problem. There's someone in there, but it's a 30-day month-long lease or rental, however you want to characterize it. So there's someone there now, but again, is the town's position that that's in violation to have a month-long lease? Because if it's not a violation, then I don't see why there'd be a problem with the continuance. If they're alleging it is a violation, I don't think that's correct, but let me know. I'm just being full disclosure to the court, Judge. There's someone in there now, but it's a full-month lease.
Well, it seems from their allegations and their notice of violation that there are multiple relatively short rentals. You got February to March 2020, 3 rentals in a month or two period, July 9th to July 15th, 2020, 5-6 days, July 26th to August 2nd, 2020, August 2nd to August 6th, 2020, September 30th, October 1st, 2020, December 23rd to 29th, January 4th to 5th. So reading it, without reading the code, it sure seems to me that the issue is a number of short-term rentals. I don't know whether the code limits the number of rentals, like an HOA to, I own a unit in an HOA. You can only rent for a minimum of 6 months, only once a year. I don't know what this code says.
I understand, Your Honor. That's what I think, but I haven't been told that. And I just think, Judge, I think fundamental due process is make it clear to me what you're saying. That's all I'm saying. That's all I'm saying, Judge. I don't know why that's hard here today to say, is the town's position that a rental for, 30 days or more or a calendar month is in violation. If it's not, then we can talk about it because there is someone there, but I don't know if the town thinks that's in violation. I just don't know. Because I want to be full disclosure on your suggestion. I could tell the court, I don't know what the evidence is going to be, how they're going to try to prove this, because I got documents otherwise, but I could tell you my client flew down here. I said, get your butt down here, Judge, okay? And that was last week, right, on a Thursday. I said, look, in my professional opinion, you retaining me, being prompt, I can't imagine that they're not going to continue this, right? And when I found out on Monday or Tuesday that no one was going to continue this for the next day, I told him to come on down. And he's here. He's a responsible person. They're upset about this. They don't want to be in trouble with the town, Judge. They don't want to be, and but. So I'd like to talk to find out if there's a resolution here. I just think due process under these facts has been violated, Your Honor. In general, whether the notice is perfect or not. It says make reasonable efforts. I don't think it's reasonable efforts when you know he's out of state and you know his phone number.
I'll take some evidence from your client and the code. So I'd like to take evidence then from your client and the code officer about their previous communications about this topic. Because not get into ifs, let us hear what they both have to say about, any communications they've had in the past that might shed some light on what the violation was, whether your client did or did not have any previous notice of this being an issue. Because frankly, if there's testimony that indicates that there was notice for some period of time that this is an issue and it continued to go on, then receiving a posting on February 5th with the hearing this 12 days later might be reasonable. If this is the first time he's heard of this, then it might be that he needs a little more time. So,
Judge, I don't mind putting some evidence on that. I believe a proffer would be, according to my client, is in July of 2019, Mr. Rodriguez spoke to them and explained what transient versus non-transient, and I believe my client has complied since then, and that's why they're surprised they're here, because without going into the merits, Judge, these dates are just wrong. I'm not sure where they think they're getting these from. And so if Mr. Rodriguez, I'll call him as a witness, whether he had a phone call and explained what transient, non-transient, and my client will say they went to Town Hall, Judge, and they got the license here, the Town of Palm Beach Shores rental property license, and then they renewed it again in 2020.
So, your client is in town now, and I'd hate to have him fly back in a couple of weeks. I don't know if he's planning on staying for a few days, because frankly, if he's going to stay for a few days over the weekend, maybe, and if it works with everybody's schedule, maybe we just have this hearing on Monday or Tuesday of next week. So that's a little bit, I'm trying to be courteous to him having flown down from Illinois in COVID and trying to avoid him flying excessively. But if he's planning on being here for a few days, but if he's got a flight back tomorrow, then that makes no sense.
They're flying back tonight, Your Honor.
Okay, flying back tonight. Where I'm having difficulty is I like to grant the continuance, but I'm having difficulty that it seems pretty clear from the notice what their issue is with this transient rental. Being in your shoes, you just really got on the case in the last few days.
Judge, I spoke to them last week. I had a
Right.
2-day evidentiary hearing by Zoom. I told them I'd agree to represent them. I said, look, I can't imagine that they're going to force you to have a hearing on this with this kind of notice just finding out. On Monday, I forwarded my office, Siegfried Rivera, Judge. I had my paralegal, or actually another attorney in my office actually did it, and who finalizes retainer agreements in my office. I said, let's get it to the client. He turned it around the same day, and I emailed Mr. Rodriguez. I pulled some people up on the clerk and said, I'd like to get a continuance. That was the response from the town clerk was, your client waited too long and delayed getting an attorney. I said, well, he reached out to me, and then I said, you know what, I'm going to send an email. And I sent an email and said, please forward this to the special magistrate, because I didn't know, they just gave me the firm. And then after that, I got a call from and I do appreciate that the town attorney called me back and said, you're not going to get, I don't appreciate you're not going to get a continuance, because I said, look, he was prompt.
Let me ask you a different question. I think the proffer is that right now there are folks renting for a period of 30 days. Is the town, is that a violation that the town is planning on citing for? Or is that, if we continue this for a week or two, is this kind of like no harm, no foul? Or is a 30-day rental going to potentially be an issue?
No, if it's continued for a week or two, that's not the issue. My issue with granting continuance to next month's hearing is that another month and a little bit more days go by with the same behavior at the property. So then we're
Okay.
here in March, and even more, transient rental has occurred. So I don't object to a week or two continuance. Again, the town's position was, this is a very small town. We have 3 witnesses and their spouses lined up. This is the regular code enforcement agenda. The town is not contemplating a March hearing. So my objection to continuance is that we are not set for a March hearing. So you're going to have to call all these people back together, and that's additional expense to the town. And again, this was posted to the property 12 days before the hearing.
Okay. With the witnesses, because I don't want to inconvenience, no disrespect to lawyers, but it's our job to be inconvenienced a little bit sometimes. But certainly, individual citizens and witnesses, I don't want to inconvenience them. So let me throw out a couple of days, and then maybe you can each confer with your clients and witnesses and see if those days work for people. So my first thought would be next Monday, the 22nd, anytime after 12:30, or I'd say 1 o'clock, so let people have their lunch. So 1 o'clock on the 22nd. My next availability would be on Friday, the 26th, at 2 o'clock. I should write these down myself.
And if we could ask the town clerk, because I believe there's a commission meeting on the 26th, or excuse me, the 22nd in the evening,
On which day?
the 22nd.
Okay, so that day is not going to work.
I don't know.
She's shaking her head no. I can see, I can hear it shaking up here. Okay, so the 26th at 2, or March the 1st, which is a Monday. Is there a commission meeting on that Monday, or just?
No, but the code enforcement officer is not, is out
Okay.
on the 26th, so that date does not work.
Which one doesn't work?
26,
Okay. How about March the 1st? In the morning, anytime.
Does that work for you, Brett?
March 1st, anytime between, say, 10 and 3? Is that doesn't work for you?
No.
Thursday, March the 4th, or Friday, March the 5th?
Did the first not work for respondents?
No, but you got a witness there who's shaking her head, it doesn't work. Does the first work for the respondent?
Is the first one. Fifth? Fifth works, Your Honor.
Does the fifth work for the town and all the witnesses?
I can't, I've started a job, and I can't do it.
Okay, so we have one witness who is not available. If we were to postpone it till the 5th, and a couple of other dates too, because what I'm hearing her saying through her mask is that she's working as a job and she's already taken off to be here. Is that what I heard you say?
Not today, it's spring training, it starts next week.
Oh, well, I can't interfere with that, believe me. What's the thoughts of?
We could solicit if since it's 3 of 4 that we have, one conflict, and that's probably going to repeat. We could solicit written statements from
Or I was
one.
going to ask, do you want to just take her testimony today?
I'm okay with taking her testimony, Your Honor, today.
I mean, I know it's out of context, and I know it's not part of a flow, but if you simply want to have her testify today, and particularly we have the court reporter there, so we can get it down.
I'll note, Judge, if they have 3 or 4 witnesses in addition to Mr. Rodriguez, and I have my clients, I'm not sure how we get it done in 2-3 hours anyhow. That's just quite frankly, because I'm going to have some cross-examination, Your Honor.
So what does the town think about taking this witness out of order?
That's fine. We don't have any objection to that.
Okay. All right, so I think we're narrowed in on March 5th. Is there any particular time of the day that anybody, I'm thinking starting at maybe 10 o'clock, because if this does take a few hours, we'd have plenty of time, but I'm also happy to start at 1 o'clock.
And were they not available? Because I think the same witness was in conflict on the first, but the first worked for all of the parties. Is that not correct?
Oh, that's true. Did the first work for everybody as well?
First does not work.
No. Does the 5th work for you, Ms. Bernard? Because I was kidding about the lawyers. I do care about lawyers, too.
Yes, that does.
Is there a particular time on the 5th with the code officer, Mr. Rodriguez, that works?
Okay, yes. Okay.
Mr. Hale, your schedule? You're good?
Well, Judge, full disclosure, my clients are trying to figure out when they got to fly, either the night before or get here in time for 12 or something like that. You understand?
Right.
I think they could be here at 12. I don't know what flights normally arrive. What time do flights normally arrive? They change.
Yeah, and with the weather that we're having right now, who knows what we'll be having then?
I would say let's try to do it at 12, if we could, and maybe just have an early lunch, and then we got whatever time, because I'm going to make myself available, Your Honor, to get this done.
Hey, town, does the 5th at 12 o'clock work?
Yes, that's fine. I believe that's going to time limit us in terms of length. Town staff, 4:30?
What time? That works till 4:30?
4:30 is the end time for town staff, so.
So 12 to 4:30. And if we have one witness going today, and then the town has the officer and 3 other witnesses, and you'll have, what, 2 witnesses, counsel? Mr. Hale?
Yes, Your Honor, although, and I apologize, Your Honor, let me tell you something.
Oh, yeah, sorry.
I know on one of these dates, he was there with his friend. His friend lives in Queens, and so if an affidavit from his friend to say, yeah, I was there that date kind of situation versus having to fly in for this, if that's okay with the court, because...
Well, rather than an affidavit, is there any objection to having any witness appear either by Zoom or by phone? Because I think to take away the right to cross-examine is difficult. I mean, I'm happy to take an affidavit, but affidavits are always one-sided, and there's always going to be some cross-examination. If there are witnesses to appear by phone or some other electronic means, if everybody agrees to that, I believe we can do that.
Yeah, I don't have any objection to that. I think the town has capability to do either phone or WebEx, which is a
Okay.
Zoom-like, for folks who cannot be here.
All right. So, I think we were agreeing that we're going to start on Friday, March the 5th at 12 o'clock, and we'll go till 4:30, unless we can wrap up sooner than 4:30. Is there anything, other than taking your testimony, is there anything else that we could do today that will shorten that day? And you both have been dancing around the merits, and I get that, and that's only fair.
Judge, what I could tell the court, and I don't mind sharing this, is, I went through with my clients with these dates. The dates that they're saying they rented, I've got, airplane receipts, and they were trying to pull up credit cards to show they bought gas and stuff like that. And so I'm not accusing the town of anything improper, but I just think their facts are wrong. And if they, I'm willing to share what I've got, because my client just wants to do the right thing here, Judge. And I don't know if they're saying, what documents that they have that they saying they were in town when my client, there was a renter there when my client was here. And
I assume that that's going to be his testimony. I'm assuming that there'll be testimony from some witnesses that says on, July 9th, I'll pick that middle one there, I, Mary Jones, saw Susie Smith, and Susie Smith told me that she was renting this property for a week. The fact that there's 4 citizen witnesses here and a code officer, I'm speculating that that would be the type of evidence that they'd be presenting. Again, I don't know.
I don't know either, Judge. What I know is, at least according to my client, that they were saying they were just going to take license plates, and I'll just tell the court and I'll tell counsel, they don't have a car here, and so when they come into town, they rent. So if there's a strange car in the driveway...
Well, it might be helpful then. We do hear from the first witness.
Yeah.
And that would be kind of be a preview for everybody of maybe the direction this goes. Now, I don't want to prejudice the town, I'm trying not to prejudice the respondent by having you kind of throw a witness in the middle of the pond and say sink or swim without any predicate for that. So if the town would rather either not call the witness or lay some kind of background, do a bit of an opening argument, present some documents, I'd receive that. So even though we'll continue the bulk of the hearing, I'm willing to move forward with presentations from both sides on the case. So and I don't want to put you in a spot where you're presenting your case.
Yeah, I'm not comfortable with that, and putting the witness on the stand without presenting some context for why we're here is difficult for that witness. So, 4.5 hours on the 5th, I don't know that we've in town had, even on these types of cases, a more than 4.5 hour hearing. So
Right.
I'm not
I
sure
can't really think of one in all these years.
Yeah, I'm not sure that we're going to get to
lots of
that
towns.
time limit anyway. So my preference, without having to go into the merits and throwing the witness up there with no context, would be that we hear them all on the 5th, because now
Okay.
we're almost a month later into the continuance. So to go into the merits now and then reconvene in a month,
Okay. Let me ask the witness, would you be available on the 5th by phone?
I won't do it till next week, because we'll get our schedule.
Okay. Okay, because if you're available at any time, in that 12 to 4:30 window, we will do a hard stop and take you whenever it works for you. And just be in touch with the town attorney and let her know with a number that you can call in, and we'll just, stop right in the middle and listen to your testimony.
Okay.
Does anybody object to that?
No, sir.
I don't object, Your Honor. I'll just tell the court, I will be full disclosure here. I'm more of a trial in court versus code enforcement, and I think the purpose here should be to find out the truth. And if there's supporting documents here that show that my client is incorrect, show it to me. This should be, a due process. My client has full opportunity. Looking at the rules, you have the authority to subpoena people, maybe you have the authority to exchange documents, that the exhibit's going to be used. I would ask that, Judge, because quite frankly, I think they're wrong. And I got documents that suggest they're wrong. And that's all. If the court has the authority to exchange what exhibits you're going to use, I'd move that the town let me know what that is, and I'll show them what I have, Judge.
Ms. Bernard, your thoughts?
That is not how we do code enforcement, nor has it ever been how we do code enforcement in this town. And we have prosecuted many of these cases without having to be subject to that.
All right. So I'll encourage, but not require, the attorneys to at least communicate to see if they can either simplify issues, streamline the hearing. You'll have a couple of weeks to obviously read those sections of the code. And hopefully by the time we come back on the 5th, the search for the truth is always the search that we're here for. So let's find out what the truth is. Let's find out how that applies to the law. Find out what the law is when you look at these sections of the code. Obviously, it's seems to be dealing with some type of transient rental issue. And then we'll just have the hearing then. I would request that, your client's already said you've already said that they've got someone in there for 30 days. So I'm assuming that 30 days will take us past March 5th. It's not like the 30 days ends tomorrow and there's going to be somebody else there next week. So is this going to be something continuous?
Judge, my understanding is there's someone in for a month and there's someone in for next month. That's, so.
So month as in the month of February and the month of March. So come March 1st, there'll be someone different in there.
That's correct, Your Honor.
Was any position that the town wants to state on that at this point?
I mean, we're sort of at the mercy of what's been booked, so I don't know that there's much we can do, But we're not here to discuss current dates anyways. The dates are listed in the notice of violation and notice of hearing, so I can't speak to future enforcement, but if there's somebody in there now and that they roll over and they're for that duration, that's what it is.
All right, so we will continue this until March the 5th at noon. I will give back to each lawyer the exhibits that are in evidence, because I don't want to hold on to them. And is there anything else before we recess for the day?
No, sir, not from the town.
Anything from the respondent?
No, Your Honor.
All right. We'll see you all on March 5th. Everyone please be safe. Keep avoiding our friend COVID. And see you all then, 2 weeks. So, Mr. Hale, these are your two. I'll put them up here. And these are yours. I'll leave them up here.
Sure.
It happens. Yeah, we'll do that.
I'll call my office also, just let them know that they're going to be very few.
Madam Court Reporter, did you need a copy of the notice of hearing for today? They happen to have an extra. I've been going to the recycle bin. I think what
Thank you.
Everyone's names as to who's present, or to who's present.
Well, we're gonna have a long day on the
You write it
5th.
down?
Yes, I do. Okay.
Eat your lunch early back there now, before the 5th.
Bringing popcorn next time. This guy's entertaining.
Thank you for setting up the table.
Oh, that was our wonderful town clerk. She
Okay.
always has your back.
Yeah.
And she'll set that, but I'm glad
Thank
that
you for
worked
setting
out.
up the table.
You're welcome. I think it's so cool what you do. My cousin's wife who's did that, and it's just like,
Uh-huh.
that's just such a amazing thing. I had an accountant, and my boss in college who was left-handed, was ambidextrous.
Yeah.
So he'd